Coyotes in Mexico are celebrating as the Supreme Court has just given them a huge windfall. So, yesterday, the Supreme Court released their decision on whether or not an asylum seeker can claim asylum when they arrive at the United States. According to them, you do not arrive in the United States until you officially touch U.S. soil. And if the administration chooses, they can deny you entry and deny you to touch U.S. soil. Thus, the only avenue available to asylum seekers who wish to claim asylum is to somehow make it into the United States illegally or undocumented in between ports of entry, through the desert, across the river, paying a coyote. So, this decision depended a lot on statutory construction. Specifically, how do you interpret 8 USC 1158? Under that statute, you are allowed to claim asylum if you are physically present in the United States or arriving in the United States. Either one works. It says that right next to each other, physically present or arriving. Asylum seekers' best argument was that it would be redundant to give both of these terms, physically present and arriving, the exact same meaning. Listen to it this way. You can claim asylum if you are physically present in the United States or if you are physically present in the United States. That doesn't make sense. It's poor statutory construction. But the Supreme Court didn't agree. It said that they were going to rely on the plain meaning. Also, they wanted to avoid extraterritorial effect, which are two other maxims in statutory interpretation. According to Justice Alito, who wrote the opinion for the court, a quarterback does not arrive at the end zone if he's tackled 1 yard before he gets there. A guest does not arrive at the house party if they close the door on him. And an asylum seeker does not arrive in the United States until they touch U.S. soil. Basically, he said, yes, it's poor statutory construction. They are basically saying the same thing twice in different words, but it's only a tool for statutory construction. They are going to rely, this court will rely on the plain meaning and also on the avoidance of extraterritoriality. So when you're constructing a law, when Congress is, if they wanted to have extraterritorial effect, meaning they want to affect its citizens or populations outside of the United States, they have to expressly say so. If they don't expressly say so, then courts have to interpret it as not having any effect outside of the United States. Because this would require the asylum statute to actually mention you're going to be checking people for asylum from Mexico, from another country. The statute should have mentioned that. But because it didn't, then the courts can't add that on, because to do so would be giving extraterritorial effect to the statute that wasn't clearly written into the statute. Moving forward, what this means is that thousands of individuals who need asylum, who are fleeing persecution, will have no choice but to find alternative routes to touch U.S. soil and claim asylum. Thanks for listening. If you want to see the full article and sources, go to The Migration on Substack.